29th. The Supreme Court just killed 91 years of constitutional law, 6-3. Trump versus Slaughter. Done. Decided. Chief Justice John Roberts, writing for the majority, summed it up in 14 words. If anything more is left of Humphrey's, we overrule it. 91 years, 14 words. The Federal Trade Commission, the National Labor Relations Board, the Equal Employment Opportunity Commission, the Consumer Product Safety Commission, the Nuclear Regulatory Commission, the FCC, the Merit Systems Protection Board, all of them, every multi-member independent agency in the federal government just lost the constitutional protection that made them independent in the first place. Now, the president can remove their leaders at any time, for any reason, or no reason at all. That's exactly what Trump did in March 2025 to FTC Commissioner Rebecca Slaughter. The termination letter gave one reason: her continued service on the FTC is inconsistent with the administration's priorities. That's it. No inefficiency, no malfeasance, no neglect, just, you disagree with us, goodbye. The Supreme Court says, that's enough. That's always been enough. Trump posted on Truth Social within hours, greatest increase in presidential power in the last 100 years. He also called it long sought by United States presidents, dating all the way back to the 1930s. He's not exaggerating. Let me show you how we got here. Question is simple. How did we go from a constitutional framework where independent agencies were specifically designed to operate at a distance from political pressure to a 6-3 Supreme Court ruling that erased all of that? I went through the filings, the dissents, the lower court history, the 15-year paper trail behind this ruling. Patterns clear when you work backwards. This didn't surprise everyone. A lot of people saw it coming, specifically the people who built it. Let me show you exactly who, and exactly when it started. Start here. The weeks before June 29th, the signals were already visible to anyone watching oral arguments. At a Supreme Court hearing earlier this year, Chief Justice Roberts publicly described Humphrey's executor, the 91-year precedent he was about to overturn, as just a dried husk of whatever people used to think it was. That's a justice telling you what he's about to write. Behind the scenes, different picture too. The administration's briefs didn't just ask the court to rule on Rebecca Slaughter's firing. According to documents filed with the court, the government asked the justices to declare the entire constitutional framework of agency independence unconstitutional. Not a narrow employment dispute, a complete restructuring request. What nobody publicly processed at the time. The government was betting the court would go all the way. June 29th. It did. Justice Ketanji Brown Jackson's dissent warned that firing scientists, economists, and experts to replace them with political loyalists is actually not in the best interest of the citizens of the United States. That's the immediate lead-up. Now, rewind further. If you want the full breakdown, subscribe. I'm walking this all the way back, from a 2025 termination letter to the 15-year legal movement that made this ruling possible. Okay, go back to late 2025 and early 2026. This is where the judicial architecture locked in. Multiple federal courts were seeing challenges to agency independence pile up simultaneously. Lower courts were consistently blocking Trump's firings, citing Humphrey's executor as binding precedent. The D.C. Circuit Court of Appeals, sitting en banc, its full panel, denied a government stay on September 2, 2025. The language was direct. According to the per curiam opinion, the government had no prospect of success on appeal because Humphrey's executor was controlling and directly on point. The court noted that a unanimous Supreme Court had upheld these protections 90 years ago, and the Supreme Court had repeatedly left that precedent in place since then. Timeline matters here. September 2nd, 2025, D.C. Circuit denies government stay. September 22nd, 2025, Supreme Court, in an unusual move, grants its own stay, allowing Slaughter's removal to proceed while the case remained on appeal. December 2025, D.C. Circuit rules in the related Wilcox case, the NLRB, finding that its rulemaking power and independent litigating authority placed it outside Humphrey's protection. Put those three data points together. The Supreme Court was acting while lower courts said the opposite, and the Supreme Court's stay order came with a signal attached. The majority noted that the government was likely to show that the NLRB exercises considerable executive power. Likely to show in a Supreme Court stay order is a preview. That phrase tells you where the majority is heading. Legal analysts reading those documents carefully knew. The final ruling was not a surprise. But here's what most outlets missed. The administration's certiorari petition asked the court to rule on the constitutionality of all for-cause removal protections simultaneously in one case. Not a narrow employment dispute, a complete constitutional restructuring request packaged as a single case. Keep going back, further back. March 2025. The immediate trigger, but the strategy behind it is older. March 18th, 2025. Trump fires FTC commissioners Rebecca Kelly Slaughter and Alvaro Bedoya. Both Democrats, both serving fixed terms, both protected by the FTC Act, which since 1914 required cause for removal, specifically inefficiency, neglect of duty, or malfeasance in office. Their termination letters, entered into public court filings, cited none of those grounds. Just one line: your continued service on the FTC is inconsistent with the administration's priorities. Slaughter sued immediately. So did Bedoya. So did NLRB member Gwyn Wilcox, MSPB member Kathy Harris, and EEOC member Jocelyn Samuels. Legal filings in public court records show that members of at least 8 independent agencies filed lawsuits challenging their removals in early 2025. What was actually happening, and the court record documents this, was a deliberate multi-agency challenge. The same constitutional argument, the unitary executive theory, was filed across multiple circuits simultaneously. Same legal theory, multiple circuits, all designed to generate the conflicts the Supreme Court would have to resolve. Law professor Michael Gerhardt said it plainly after the ruling. It took years of planning by conservative groups to overrule Humphrey's executor. Years. Documented in legal scholarship and court filings both. The March 2025 firings weren't impulsive. They were a launch sequence. Every termination letter, every lawsuit filed in response, every circuit ruling, all public record, available on Pacer today. This isn't speculation. These are documents. Now, opposition perspective. Full picture. But okay, full picture. The White House and those who genuinely support this ruling have a completely different interpretation, and it deserves to be heard fairly. Their argument, and it's not nothing. The Constitution assigns the executive power to one person. Article 2. Not to a federal trade commission, not to a board, not to commissioners appointed by previous administrations and operating without accountability to the current one. Independent agencies aren't in the Constitution. Congress invented them, specifically in the 20th century. That invention created entities wielding enormous regulatory power over every American's life, with no elected official able to remove them. Their position? That's not independence. That's unaccountable power dressed up as neutrality. Second point, and it carries real weight: accountability. If you cannot fire the person making regulatory decisions, you cannot hold them accountable. Nobody voted for Rebecca Slaughter. Nobody voted for an NLRB board member. These officials write binding rules, issue enforcement actions, adjudicate cases affecting hundreds of millions of people. Until June 29th, no president could remove them, regardless of how voters felt about their decisions. Roberts wrote it directly in the majority opinion. Subordinates who exercise the president's power are subject to removal by him. Then and only then can they remain accountable to the president and the president to the people. What the administration points to, Myers versus United States from 1926, which upheld presidential removal power over executive officers. SELA Law versus CFPB from 2020, which struck down single director removal protections. Alexander Hamilton's Federalist 70, unity in the executive, as a core founding principle. And Roberts' own observation that Humphrey's was a result in search of a rationale for decades. Even Ilya Shapiro of the conservative Manhattan Institute acknowledged the complexity. The fourth branch's powers still exist. They have just been reassigned to the president. That's a concession that the administrative state didn't shrink. It centralized. Their version, this isn't a power grab. It's restoring what the framers designed. One executive, removable officials, a chain of accountability that ends at someone voters can replace. My read? The constitutional text supports parts of that argument. Myers is real. SELA law is real. The Federalist 70 language has genuine weight, but the documented litigation strategy, engineering simultaneous challenges across multiple circuits, timed to this specific court's composition, reflects political calculation alongside constitutional theory. Both things exist in the record. What I'm showing you, the documented trail, you decide what it means. Going back further, following the trail, hit like. Going through 15 years of court filings to build this kind of breakdown takes time. That like button tells me it's worth it. Okay, the beginning. Go further back than March 2025, before the firings, before Trump's second term. The legal groundwork for this ruling stretches back more than 15 years, and the paper trail is public. Here's what I found. 2010, Free Enterprise Fund versus Public Company Accounting Oversight Board. Nobody covered it as a landmark at the time, but the Supreme Court ruled against double-layer removal protections, where a board member could only be fired by an agency head who could only be fired by the president for cause. The court found that insulating officials that far from presidential accountability violated Article 2. The ruling was narrow, but conservative legal scholars saw it immediately for what it was, a crack in Humphrey's executor's foundation. The majority language was pointed. Such multi-level protection from removal is contrary to Article 2's vesting of the executive power in the president. That's 2010. 16 years before June 29th. Then 2020, SELA Law versus CFPB. Roberts writes the opinion. Single director agencies like the Consumer Financial Protection Bureau cannot have statutory removal protection. Humphrey's technically survives, but Roberts writes something specific. Humphrey's applies only to multi-member agencies that do not wield substantial executive power. That phrase is a roadmap. Read it as, if you can demonstrate a multi-member agency wields substantial executive power, it falls outside Humphrey's protection. Legal scholarship from conservative constitutional scholars, published from 2021 onward, mapped exactly this argument. The strategy, challenge the FTC as wielding executive power, force the court to apply the SELA law framework to multi-member boards. The Atlantic reported in March 2025, the same month Trump fired Slaughter, that independent agencies never stood a chance under Trump. Scholars quoted in that piece confirmed the campaign had been in preparation for years. The paper trail runs from academic articles to moot court sessions to coordinated amicus brief filings from 2010 to 2026. First domino, a 2010 ruling, most coverage dismissed as narrow accounting oversight law. Second, a 2020 roadmap written into the Roberts opinion itself. Third, a litigation launch sequence in March 2025. Final step, June 29th, 2026. You can trace the line. Now let me put it in order. Stay with me. I'm about to run this timeline forward in chronological order. It hits differently when you see the sequence all at once. What do legal scholars say about what just happened? Constitutional law professor Erwin Chemerinsky, dean of UC Berkeley School of Law, was direct after the ruling. Agency independence is now gone. 3 words, his entire assessment. Law professor Michael Gerhardt put it in historical terms. It took years of planning by conservative groups to overrule Humphrey's executor. Not legal evolution, a planned campaign with a documented timeline. Administrative law scholar Steve Schwinn offered the forward-looking warning: expect the hyper-politicization of previously independent federal agencies. Translation: agencies regulating workplace safety, consumer products, labor rights, and financial markets now operate in an environment where their leadership can be replaced the moment their decisions displease the sitting president. Consensus among legal professionals: all for-cause removal protections at affected agencies are now constitutionally unenforceable. NLRB, EEOC, NRC, NTSB, CPSC, MSPB, FCC, all affected. Past agency decisions and enforcement actions may face retroactive constitutional challenges. The Federal Reserve is temporarily exempted in Trump versus Cook, but lower court litigation continues. One additional layer worth noting: Justice Gorsuch's concurrence adds a complication that cuts both ways. He writes that overturning Humphrey's, quote, doesn't cure every constitutional disease in the administrative state. His point: the agency's powers didn't disappear, they were reassigned to the president, not a smaller administrative state, a more concentrated one. That's the expert read across the ideological spectrum. So, put it in order. Fast version. 2010, Free Enterprise Fund versus PCAOB. First crack, double-layer removal protections flagged as constitutionally suspect. 2020, SELA Law versus CFPB. Single director protections struck. Roberts writes the roadmap language limiting Humphrey's. 2021 to 2024, conservative legal scholars and affiliated networks develop explicit multi-agency litigation strategy targeting multi-member boards. January 2025, Trump takes office. White House counsel pre-armed with constitutional arguments. March 18th, 2025, Trump fires Slaughter, Bedoya, Wilcox, Harris, Samuels, and members of at least 8 agencies simultaneously. Summer 2025. District courts block firings. Humphrey's executor holds, for now. September 2nd, 2025. D.C. Circuit upholds lower courts. Supreme Court grants its own stay. December 2025. Circuit-level rulings continue dividing. Early 2026. Supreme Court grants certiorari on the broadest possible constitutional grounds. June 29th, 2026. 6-3. Trump versus Slaughter. Humphrey's executor overruled. 15 years. Each step documented. Could this have been stopped? Courts at multiple levels tried. They were ultimately overruled by the same institution they were citing as authority. Why wasn't it stopped? The strategy was built for exactly this court's composition. Now, what this means for you. Useful? Hit like. This kind of research means going through 15 years of court decisions, and that like button tells me it's worth the time. Why should you care? Real talk. Here's how this ruling reaches into daily life. The agencies that just lost their independence aren't abstractions. The EEOC is the federal body you file with if you experience workplace discrimination. It now operates under leadership directly accountable to the White House, removable the moment its enforcement decisions don't align with administration priorities. The NLRB protects your right to organize and collectively bargain at work. Its board members now serve at the president's discretion. The Consumer Product Safety Commission determines what products are safe enough to sell to your family. The Nuclear Regulatory Commission oversees your regional nuclear power plant. If you work, if you buy products, if you live near regulated infrastructure, this ruling altered the institutional framework governing all of it. If you have investments, pay attention. According to legal analysis from major corporate law firms reviewing the ruling, antitrust enforcement, merger review, and consumer protection enforcement, all of which affect market pricing and competitive behavior, can now shift with political leadership changes. Large mergers that might previously have faced scrutiny could see reduced enforcement pressure under politically aligned FTC leadership. NLRB precedents on union elections and joint employer standards are now subject to rapid reversal with each administration change. Not advice, just what the legal framework now permits. Legal experts estimate at least 24 multi-member independent agencies are affected. One immediate data point. Just last week, July 8th, former EEOC Vice Chair Jocelyn Samuels voluntarily dismissed her lawsuit challenging her own firing. Why? Because after Slaughter, her case had no constitutional ground left to stand on. Case: Samuels versus Trump, number 1:25-CV-01069. Dismissed. That's how fast this is moving. Justice Gorsuch said it in his concurrence. The fourth branch's powers still exist. They have just been reassigned to the president. The administrative state didn't shrink. It's centralized. If you work in a regulated industry, finance, healthcare, energy, transportation, agriculture, or labor, the rules governing your field are now written, enforced, and adjudicated by officials who can be fired the moment their decisions displease the White House. That's not theoretical. That's constitutional reality as of June 29, 2026. What you can do right now: track leadership changes at any independent agency affecting your industry or employment over the next 60 to 90 days. If you have any active complaint pending before the NLRB, EEOC, or CPSC, consult counsel about how Slaughter affects the process. Watch the Clarity Act Senate timeline. It's the first live legislative test of whether Congress can build any structural safeguards post-Slaughter. Information matters. What happens now? July 16, 2026. Court-ordered deadline for former EEOC Vice Chair Jocelyn Samuels to explain why Slaughter didn't require dismissal of her case. She voluntarily dismissed on July 8th, before the deadline. Coming weeks, the Clarity Act, a crypto market regulation bill already passed by the House, is heading for a Senate vote. Legal advocates are pushing senators to amend it with quorum requirements mandating bipartisan commission membership before agencies can take action. First post-Slaughter legislative workaround being seriously tested. The Federal Reserve question isn't settled. Trump versus Cook exempted Fed governors 5-4, a one-vote margin. If the Fed's structure is challenged again with different case facts, that margin gets tested. What's still unknown, whether Congress can craft a constitutionally viable response. Any statute restoring removal protections faces the same Article 2 challenge Slaughter just resolved. The quorum strategy is the narrow lane they're exploring. Reporting suggests legal advocates on both sides are watching the Senate Clarity Act vote closely as the first real institutional test of congressional authority post-Slaughter. Clock's running. That vote could come within weeks. Subscribe. When the Clarity Act vote happens, when the next agency leadership change drops, I'll break it down. The post-Slaughter story is still writing itself. Where things stand right now. Monday, July 13th. Trump versus Slaughter. Decided. 6-3. Humphrey's executor overruled. Full text available at supremecourt.gov. Trump versus Cook. Federal Reserve governors exempted, for now. Litigation continues in lower courts. Affected agencies. At least 24 multi-member independent bodies now subject to at-will presidential removal of leadership. EEOC. Jocelyn Samuels voluntarily dismissed her case July 8th, legally resolved. NLRB. Gwynne Wilcox litigation directly resolved by Slaughter precedent. Congressional response. Both parties discussing the ruling. Democratic legislative options constitutionally constrained. The quorum strategy via the Clarity Act is the active legislative play. Trump's position. Actively celebrating, calling it greatest increase in presidential power in the last 100 years. Federal Reserve, exempted, holding at 5-4, watch the lower court litigation. Not final, the Federal Reserve question, and whether the Senate acts on the Clarity Act, still moving. That's the full picture. Started with June 29th's ruling, walked it back to a 2010 accounting oversight case most people ignored. Every step documented. Court filings, public record, legal scholarship, termination letters filed in federal court, the text of the Supreme Court opinion itself. Surface read, a sudden ruling that rewrote the Constitution overnight. But when you trace it backwards, the argument was built over 15 years. The litigation was engineered across multiple circuits simultaneously. The court it was written for was assembled during that same period. What looks like a surprise is actually the final step of a documented legal campaign, visible in public record to anyone following it carefully. I'll keep following this. Working backwards shows you what working forward missed. Subscribe for analysis, not just updates. When the Clarity Act vote happens, I'll be there. When the Federal Reserve case moves, I'll break it down. More developments ahead. Stories still developing. See you then.